Good evening, attorney. Good evening, classmates. Our group 2, is assigned to report about case law and precedent. Readings can be found in the Legal Method Essentials Book 4.0 of Gatmaitan. Allow me to introduce our team. Group 2 members include Rizia Jazil Perez, Excelsi Bation, Miko Panta, Jeneline Seduco, Michelle Elehio, Iyer Mundulay, Alexandra Picar, Edsel Jun Amado, Vladimir Kobayashi, and yours truly, Rodessa Cascaro. The topics that we will be discussing tonight are court decisions as law, Article 8 of the Civil Code, repositories of decision, personal opinion of judges, form of decisions, the syllabus, dispositive portion, ratio decidendi, and obiter dictum. Again, I am Rodessa Cascaro and I am tasked to report on court decisions as law. So courts are mandated to settle disputes between real conflicting parties through the application of the law. Judicial decisions assume the same authority as a statute itself until authoritatively abandoned, necessarily become, to the extent that they are applicable, the criteria which control the acts of the parties and those duty-bound to enforce obedience to the decision. The decisions are laws by their own right because they interpret what the laws say or mean. Unlike rulings of lower courts, which bind the parties to a specific cases alone, decisions of the Supreme Court are universal in their scope and application and equally mandatory in character. They are binding judicial precedent based on the doctrine of stare decisis. However, a case not yet decided is deemed settled and closed to further argument if decision is still in the subject of a motion for reconsideration. The application or interpretation placed by the court upon a law, part of the law as of the date that the law was originally passed or as of the date of the enactment. However, when a doctrine of the court is overruled, or if the court adopts a different view, or when there are reversal of the doctrine, the new doctrine applies prospectively, meaning it should not apply to parties who relied on the old doctrine and acted in good faith. A lower court cannot re-examine and reverse a decision made by the Supreme Court. All lower courts are bound by Supreme Court decisions. The judiciary has to speak with one voice to assure stability in legal relations to avoid confusion. The Supreme Court is given the exclusive and ultimate authority to interpret the laws. A decision made by the Court of Appeals does not establish judicial precedent. A ruling of the Court of Appeals on any question of law is not binding on the Supreme Court. Thus, the Supreme Court explains the decision of the higher court binds the lower courts. The courts of coordinate authority do not bind each other, and the one highest court does not bind itself because it is invested with the innate authority to rule according to its best lights. The next presenter will discuss a bit about Article 8 of the Civil Code. Thank you and good evening.
So we have now Article 8 Civil Code. I will discuss briefly of the background for this article. So we have Republic Act number 386, which is an act to ordain and institute the Civil Code of the Philippines. So we have here the Article 8, which is the judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. We will talk about the definition of some words important in this topic. So we have first judicial decisions. What is judicial decisions? It is interpreting the law as well as the judicial customs where decisions are made with notwithstanding the Article 1 Civil Code of the Philippines, absence of applicable statutes or customs. So we have here judicial decisions applying to or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. Only decisions of the Supreme Court establish jurisprudence and are binding on all other courts. Next, we have judiciary, or what we call the judicial system or court system. It is a system of courts of law. The judges of these courts, we have the branch of government in which judicial power is vested. So it is a system of courts that interprets and applies the law in the name of the state. The judiciary also provides a mechanism for the resolution of disputes under the doctrine of the separation of powers. It doesn't make a law or enforce the law, but it interprets the law and applies it to the facts of each case. But with this branch of the state is often tasked with ensuring equal justice under law. It usually consists of final appeal together with the lower courts. Next, we have judicial power. For judicial power includes the duty of the courts of justice to settle the actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So we have the scope of judicial power. We do have the adjudicatory power, judicial review, and lastly, the incidental power. Adjudicatory power to settle the actual controversies involving right and to determine whether there has been a grave abuse of discretion to lack or excess of jurisdiction. We have also the judicial review, which interpret the law and make them binding judgment and constitutionality of the law. The incidental power, by the way, is the power of essential powers essential to the discharge of their judiciary functions. Let's talk briefly about the Supreme Court, which is the higher court of the Philippines, composes of 15 judges. One is the Chief Justice, which is appointed by the President, and 14 associate justices. Supreme Court actually was established in the Second Philippine Commission on June 11, 1901, through the enactment of its Act number 136, an act which abolished the Real Audiencia de Manila, the predecessor of the Supreme Court. And we have the Article 8, Section 4 of the Constitution explicitly provides for the cases that must be heard in bank, and Section 4 for cases that may be heard in by divisions. By the way, we'll have the information about the in bank on the later part. Next, we have the Supreme Court exercises the following powers of the Supreme Courts. So we have first exercise jurisdiction over cases, which is affecting the ambassadors, other public ministers, consuls, and over petitions for certiorari, prohibitions, mandamus, cowaranto, and habeas corpus. Second, we have review, revise, reversed, modify, or affirm on an appeal for certiorari as the law or the rules of court may provide. Final judgment and others of the lower courts in. We have the scope, all cases in which the constitutionality or validity or any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. Second, we have all cases involving the legality of any tax imposed, assessment, or toll, or any penalty imposed in relation thereto. So we have also all criminal cases in which the jurisdiction of any lower court is in issue. Fourth is the all criminal cases in which the penalty imposed is reclusion perpetua or higher. Fifth is all cases in which only an error or question of law is involved. So for the third, we have a temporary judges of lower courts as to other stations as public interest may require. So these such temporary assignments shall not exceed 6 months without the consent of the judge concerned. So we have the fourth power for the Supreme Court is order a change of venue or place of trial to avoid a miscarriage of justice. Fifth, we have promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts. The admission to the practice of law, the integrated bar, the legal assistance to the underprivileged. Such rules shall provide a simplified and inexpensive procedure for a speedy disposition of cases, shall be uniform for all courts and the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts, quasi-judicial bodies shall remain effective unless it is disapproved by the court. So we have lastly, appoint all officials and employees of the judiciary in accordance with the civil service law. And we have lastly the in-bank session. So this is a constitutionality issues which involves treaty, international law, proclamations, executive agreement laws, presidential decrees, proclamation, and orders. Where majority of the members of the judiciary who participated in the learning. So we have if majority votes are not obtained, constitutionality is upheld. With the 15 members of the Supreme Court, the quorum number of persons in quorum will be 8 and the votes required is 5. So administrative proceedings for the dismissal of a judge of a lower court. So basically, it's just an overrun for a brief review of Article 8. So thank you.
We will move forward to the repositories of decision. Given that binding precedent requires the publication of reported cases, the Philippines has an official repository of Supreme Court decisions. This is called the Philippine Reports. We also have unofficial reporters, such as Supreme Court Reports Annotated or SCRA, that is published by Central Books and begins from 1901 to the present. Another official repository is CD Technologies Asia. This platform makes the complete text of Supreme Court decisions available on DVDs and online. Supreme Court decisions and resolutions are available online because the court issued a resolution holding in abeyance the uploading of unsigned, extended resolutions, and unsigned resolutions with opinions to the Supreme Court website. Rule 14 of the Internal Rules of Supreme Court says that both the unsigned extended resolutions and unsigned resolutions must be uploaded to the Supreme Court website, whether they are extended or minute, with separate, concurring, or dissenting opinions or disposes a case after the filing of the comment, all must be uploaded online.
Good evening, everyone. My name is Miko M. Panta, and I am a member of Group 2. So the topic that was assigned to me was the personal opinions of judges. Let me share to you about this topic. So, as to got my time book version 2, the Supreme Court frowns upon the inclusion of personal views in court decisions. Decision of court should contain only opinion that is relevant to the opinion for the court for a decision. After all, courts are not concerned with mere wisdom's morality of laws, but only the interpretation and application of the law. Judges should refrain from expressing irrelevant opinions in their decision which may only reflect unfavorably after upon their competence and the propriety of their judicial actuations. Interpret speech that talks from equanimity and judiciousness that should be constant hallmarks of dispenser of justice. Second reference, personal opinions of judges is what we call jurisprudence, which they interpreted and understand the intent of the framework in some cases to provide clarity and transparency of the certain issue. Personal opinions of judges also are final and new deep interpretation of law unless repelled by new cases. Personal opinions of judges as to Gatmaitan reference. Judges may provide opinion as long as it is correlated and does not question the law. Thank you.
Good evening, everyone. I am Maria V. Perez. I was assigned to talk about the forms of decisions. But before that, let's talk about what a decision is in general. So a decision is the adjudication or settlement of a controversy by a court of law. But for a decision to be valid, no, it has to follow the constitutional mandate. No, it has to comply with the form, the procedure, and substantive requirements laid out in the Constitution and also the rules of court and the circulars and orders of the Supreme Court. Now, while there is no prescribed or strict form for decisions, no, we have what we call certain guidelines that should be observed by judges while they are crafting their decisions. So an example of this guideline is that decisions should be concise, it should be clear, no, and it should be complete in all its vital details. Well, why? Because it has to be clear for those involved parties, no, for them to easily understand how the judge arrived at his or her conclusions. Desirably, decisions should also be written with both brevity and substance. Sa madaling sabi pa, it should be short enough and concise, but long enough to cover the essentials. And it should be emphasized, no, that we should not compromise substance over brevity. To quote Yao versus Court of Appeals, brevity is desirable, but it should not be used as a substitute for substance. Well, there is no subscribed form for decisions. Our Supreme Court, in the case of Velarde versus Social Justice, suggested 5 essential parts that make a good decision. 1, statement of the case. 2, statement of facts. Next, issues or assignment of errors. Court ruling. And number 5 is a dispositive portion. But to better understand these essential parts of decision, no, it is best to discuss it vis-a-vis with the components of a decision, which were laid down by Kenneth J. Van de Velde, the author of Thinking Like a Lawyer, An Introduction to Legal Reasoning. And according to Van de Velde, a well-written decision has to have the following. So according to him, a well-written decision has to have a description of facts or narration of events that gave rise to the dispute submitted for the court's resolution. And in relation to this, a decision must also have a rundown of procedural history, meaning no, the events that occurred in the lower appellate courts during the course of litigation, beginning with the filing of a complaint. Next, a well-written decision has to lay down the question presented. So when we talk about that, these are the questions that the appellant is asking for the court to decide upon. And in relation to these questions, a well-written decision must include the rule of law or rules of law and the application of this law or laws to the fact. Well, the former are the principles that apply to the case before the court. The latter determines whether each element of each rule applies to the facts before it. So, yan yung difference ng dalawa. This now leads us to the last 2 components laid down by Van de Velde, which are the holding and disposition. On one hand, holding is the decision of the court with respect to the question presented in the case, while on the other hand, disposition is the procedural directive. Again, procedural directive that gives effect to the court's decision. So to better appreciate all these things no, na I've been talking about, here's a quick rundown of the parts of a decision. Kindly refer to the Gatmaitan book, the 4.0 version, page 165 to 174. So at the beginning, or yung first part ng ating decision, it has to have a docket number. So if you could see here, there's a docket number, GR number 193960. Next, we have the date when the decision was promulgated, January 7, 2013. Next, dito sa after this line, we have the name of the ponente or the name of the justice who wrote the decision. Next is the statement of the case. So before the court is a petition for certiorari and prohibition assailing, blah, blah, blah. So this part explains the nature of the case. While the next one is the statement of the facts, no, yung mga important dates and ano yung mga nangyari. So at the latter part, we have here the RTC rulings, which explains no the decision of the RTC and bakit ngayon we have this case or why the court is trying this case. Next is we have the issues. So herein, the court identifies the issues or assignment of errors. And at the bottom part, we have the court's ruling. It explains the rationale of the case. And at the bottom or at the last part, we have here the dispositive portion, where it must be stated whether the complaint or the petition is granted or denied.
Good evening, attorney. Good evening, classmates. I am Michelle Ilihio. Together with my partner, Janelyn Siduco, we will discuss what is syllabus. So, partner, what comes in your mind when you hear the word syllabus?
For me, it is an outline or a short summary of the topic.
So here, we will know what is the relation of the syllabus of the previous topic of the previous reporter.
Should we include syllabus in Supreme Court decision?
No, because it is written in the book of Katmaitan that a syllabus is not part of the Supreme Court's decision. It is merely the work of a reporter who gives his or her own understanding of the decision. Therefore, it is not part of the Supreme Court's decision.
Exactly. It is merely work of a reporter who give his/her own understanding of the decision. A counsel should not cite a syllabus in place of the carefully considered text in decision of court.
So that is the reason why it is not part of the Supreme Court's decision, because it is just the understanding of the reporter.
So, what is the reason why it is not included in the Supreme Court decision?
Because it is the duty of all the officers of the court to cite the rulings and decisions of the Supreme Court accurately. In Canon 10 of the Code of the Professional Responsibilities, Rule 10.2, a lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language or the argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by repeal or amendment, or assert as a fact that which has not been approved.
Lawyers and litigants are mandated to quote decision of the Supreme Court accurately.
So that is the reason why a syllabus is not included in the Supreme Court's decision, because they should write the Supreme Court's decision accurately. And syllabus is just the understanding of the reporter.
Good evening. I'm Iyar Mundulay from Group 2. I'm to present the disposition or the dispositive portion or the value as reference in the commentaries of Katmaitan rather. So please allow me to share my screen. As stated in the commentary of Katmaitan, the disposition or the value of a case controls of any issues filed before a court, and such part of the decision carries with it the specific directives or the enforceability portion of the decision of it. In general rule, the interpretation of the ratio decidendi or the reason of the decision should be in such a way that the entirety of the court decision should be considered, and that there has to be a harmony between the value or the dispositive portion of the court decision, that of the body of the decision. That is rule. Again, going back, the body of the decision merely carries with it the opinion of the court as regards the resolution of the case. And to a great extent, the body of the decision carries the full intent of the decision of the court. However, the body of the decision or the ratio decidendi does not have an enforceability, considering that such portion is only limited to the value or the dispositive portion of a case. Now, the general rule, as mentioned, is that the dispositive portion or the value controls the resolution of a case, meaning the directives, the orders explicitly stated in the value or the dispositive portion will control the resolution of the case. That is the general rule. However, there are instances wherein there is inconsistency between the ratio decidendi or the reason of the decision to that of the value or the dispositive portion of the court decision. The general rule only applies when the value of a final decision is, number one, definite, if it is clear, unequivocal, and can be given effect without the need for interpretation and construction. Now, to substantiate a point as to whether when we are going to apply the exception to the rule, I have here a case which is a petition for a certiorari or a review of a lower court's decision, in this case, the decision of the Court of Appeals with regard to the complaint of the respondent. So this was filed before the Supreme Court by the petitioners Wilson Ong, Ching Kian Chung, and the Director of the National Library as the petitioners, and versus China National Cereals, Oil, and Foodstuffs Import and Export Corporation, Cereal Oil, Food, Shandong, Cereal and Oils, as represented by Attorney Benjamin Irao Jr. The context of this petition for a certiorari started with the civil case filed by the respondent, which is Wilson Ong. Respondent filed a civil case against the respondents, or the petitioner filed a civil case against the respondents over an alleged copyright infringement of the petitioner's copyrighted packaging for a food, which was alleged that the respondent used such copyright or such packaging without the petitioner's consent. So the civil case was filed before the Quezon City Regional Trial Court, Branch 94. Subsequently, the respondent, as represented by Attorney Irao, filed a case to nullify the certificate of copyright issued to the respondent. But the case was filed before the Manila Regional Court. Case filed before the Manila Regional Trial Court consummated with the decision of the court ordering the cancellation of the certificate of copyright issued to the respondent. Because of the decision of the Manila Regional Trial Court, the petitioner filed an appeal before the Court of Appeals, arguing that the case filed before the Manila Regional Trial Court is in violation of the multiplicity of suits or litis pendentia and forum shopping, which litis pendentia and forum shopping are sufficient grounds for the dismissal of the case. Litis pendentia requires three specific requisites for such condition to be committed. Number one is that the identity of the parties involved should be one and the same to an existing case. So that's one. Second, the rights and the relief prayed for, as asserted by a complainant, should be similar or should be in consonant to the same rights and relief being subject of a case. And lastly, the identity of the such that judgment in one case, regardless of which party is successful, would in turn amount to res judicata of the other case. And as reviewed by the Court of Appeals based on the arguments posed by the petitioner and based on the evidences, the Court of Appeals issued a ruling in favor to the petitioner stating that the case filed before the Manila Regional Trial Court is in violation of the litis pendentia and forum shopping. And further, they affirmed that such are sufficient grounds for the dismissal of the case in Manila RTC. So that was the ruling of the Court of Appeals. However, if we are going to read the value of the case of the Court of Appeals, it reads as follows. So this is the disposition of the Court of Appeals decision. Wherefore, the instant petition is hereby granted and as prayed for by petitioner. The order dated January 27, 1994, issued in civil case number 94-68836 by branch 33. So this was the case filed by the respondent before the Manila RTC. Is hereby annulled and set aside. So the Court of Appeals ordered that such case will be annulled and set aside. And let's try to focus on the underlying value. And it continues to say, although the prayer or for dismissal of the complaint in Manila may be pursued before said court during the proceedings. So this tells us that the underlying portion of the value falls short with the ruling of the same court. Meaning, as we have stated, based on the ruling explicitly outlined in the court decision of the Court of Appeals, they affirm that the violation of litis pendentia and forum shopping sufficient grounds for the dismissal of a case. However, in the value that they have issued, they gave the discretion as to the dismissal of the case over to the Manila RTC. So, in short, the value of the Court of Appeals disposition is not definite and falls short with that of their ratio decedente or the reason for the decision. And because of this, the petitioner, Mr. Wilson Ong, petitioned for a certiorari before the Supreme Court for the Supreme Court to review the decision of the Court of Appeals. And last portion of the decision where the value is stated reads as follows. The Quezon City Court and the Manila Court have jurisdiction over the case. However, when the Quezon City Court acquired jurisdiction over the case, it excluded all other courts of concurrent jurisdiction from acquiring jurisdiction over the same, which means to say that since the case was filed in Quezon City prior to the case filed in Manila RTC, considering that they both have the same respondents, they both have the same and rights being argued upon, and they both have the same, or they effectuate the same decision to whichever party may win over the case. The Manila Regional Trial Court has no jurisdiction over the case. They have no jurisdiction over the case. And the Supreme Court further ruled that to hold otherwise would be to risk instances where courts jurisdiction might have conflicting orders. And therefore, in the decision or the dispositive portion of the Supreme Court's reads as follows. Wherefore, the assailed decision of the Court of Manila, Branch 33 in civil case number 94-68886 is annulled and set aside, which actually affirmed the prior decision of the Court of Appeals. Now let's continue. Said case is ordered dismissed, prejudice to the continuance of the proceedings before the Quezon City Court, where civil case number Q 93-17628 is pending. We can see here clearly that the Supreme Court considered the decision of the Court of Appeals or considered the ratio decidendi of the Court of Appeals, and they issued a specific order as to the dismissal of the case filed before the Manila RTC, of which that is the main purpose why the petitioner, Mr. Wilson Ong, filed an appeal before the Court of Appeals. So in summary, these are the conditions where exceptions to the general rule is warranted. Number one, when there is ambiguity and uncertainty between the value and the ratio decidendi or the reason of the decision, the value should consider or should find support from the body of the decision. Number two, when there is extensive and explicit as presented in the decision of the case. And lastly, where the conclusion in the body is clear that there was a mistake in the value or in the dispositive portion. So these are the general conditions for us to apply the exceptions to the general rule. And if there is ambiguity caused by an omission in the value, the court may clarify such through an amendment even after the final judgment. When a doubt or uncertainty exists between the value and the body of the decision, the court must harmonize the value to that of the reason of the decision or the body of the decision. And lastly, the court may issue a writ of execution if there are inaccuracies in the portion. So that's it.
Classmates, I am Alexandra Picar and I will be sharing about ratio decidendi and obiter dictum. These two are not something you learn from Hogwarts. Ratio decidendi, according to Gatmaitan, is the ultimate issue directly before the court expressly decided in the course of the consideration of the case. Ratio decidendi constitutes binding precedent. According to Legal Interpretation Institute, when considering earlier cases as precedent, courts often ask parties to be very clear about how they interpret the main guiding principle or the ratio decidendi of the earlier case. In a simpler explanation, ratio decidendi is the factual point or the chain of reasoning in a case that drives the final judgment. On the other hand, obiter dictum, according to Gatmaitan, is a matter that is not raised expressly, therefore it was not a prerequisite in the disposition of the case. It is plainly opinion, entirely unnecessary for the decision of the case, and are not binding as precedent. In a layman's term, obiter dictum is a judge's incidental expression of opinion, not essential to the decision and not establishing precedent.
Good evening, I'm Vladimir B. Kobayashi. In my talk, we're going to learn about obiter dictum and how does it differ with ratio decidendi. Obiter dictum, or dicta for plural, is Latin for something said in passing. Unlike the ratio decidendi, obiter dictum is an opinion of the Supreme Court that does not constitute a judicial precedent. Therefore, it is not binding and lacks the force of adjudication. However, some obiter dicta are considered persuasive and may be followed. Hence, there are two different degrees of weights for obiter dicta. On the light end, there are simple passing remark, and on the heavy end, there are statements that have been fully argued, as if it were the ratio. Some examples of obiter dicta include personal view of the judge, pronouncement on standing as referenced in Opsa versus Facturan, and procedural rules in the conduct of appeal in Mercado versus People. Thank you.